Well, today Kyle had his bail hearing, and Thomas Binger had it all laid out. He had his arguments settled up. Let's see here, I'm gonna get him labeled as a white supremacist, and I'll talk about the flashing of the symbol and drinking. He was drinking in a pub. I've got us all laid out, and this is going to be impressive. This is going to be awesome. And then he ran into Judge Bruce Schrader, who would have none of it. Oh, Thomas Binger, you're a real work. Although I will have to say that John Huber tended to make you look almost sane. Uh, so the prosecution got its first taste of what they're going to run up against in a real trial, and it didn't look too good. It turns out that Judge Bruce Schroeder is a pretty sensible man, which spells death for Binger's case. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnnie Walker Dread to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnnie Walker Dread Show.
All right, let's play this. And all of the usual suspects came out and pretty well played their cards as they were given. And not a lot of surprises here, but it's kind of interesting. What they did was they ran up against a judge who was simply going to examine this system, this situation, from a reasonable, sensible standpoint, which pretty well takes care of Binger's approach. He wasn't ready for that. All right, let's go.
All right, and there's also Mr. Gage Grosskreutz, am I pronouncing it right?
Yes, Your Honor.
Well, that's strange. Gage told me that I was mispronouncing his name, and that's what I've been calling him, Gage Grosskreutz.
Okay, there's Kimberly Motley coming in right now. Okay, and would you identify yourself, please, ma'am?
By the way, the IQ of the room just plummeted. You'll see why.
Ms. Motley, would you identify your interest in the case?
I'm sorry, yes, I'm represent.
I can hear you.
Yes. Sorry, Your Honor, good afternoon. I'm representing Gage Grosskreutz as well as the estate of Joseph Rosenbaum.
All right, and it's here on motions as I indicated, and I think the first was brought by the state. So, Mr. Mayor, Mr. Zaff, I did review all the written materials were submitted, so if you want to add something to what you've already supplied, go ahead.
Thank you, Your Honor. The state had filed a motion to increase the defendant's bond by $200,000 and asked the court to issue an arrest warrant for the defendant because he's violated 969.10, which requires him to update his address with the court within 48 hours of any change of address. I want to stress, as the court is aware, I think everybody's aware, this is a very unusual situation to have someone facing these types of charges who has been released from custody. Typically,
it's not. He's an absolute bald-faced liar. I've said this many times. Crystal Kaiser, who's being charged by his office, was arrested for first-degree murder in Kenosha, and she has been able to provide bail. She is free on $400,000 bond that was paid for by an association that scraped up the money for her.
in a case like this, the courts set a substantial cash bond, upwards of $1 million or more. In this case, it's $2 million. That's obviously a large amount of money for anyone to post.
Yeah, that's right. You just got done saying that typically in a case like this, it's $1 million. And, well, Kyle's posted $2 million. And yes, it is an awful lot of money. for someone to post, and you're just upset that he was able to come up with it.
In this case, Mr. Rittenhouse was fortunate that his case drew the attention of people around the country who donated money to a foundation that was run by attorney.
Let me interrupt you.
Yeah, by the way, I don't know how the judge is going to feel about this, but it doesn't matter. The idea of bringing up who paid for the bail seems odd for a bail hearing. I don't think the judge really cares how he got the money unless he robbed a liquor store or something.
If I might for a moment. I did actually watch the video of the initial appearance, and you already knew this at that time, and in fact you brought it to Judge Keating's attention that the defendant, that you did not believe the defendant was living at the Illinois address, and that he was living in a safe house. And so I guess my starting issue is, if this has already been presented and argued before Judge Keating, what triggered the motion now?
And I've said this in my other videos as well, that if you go back to the November 2nd bail hearing, they already knew that Kyle was living in an undisclosed residence. Kyle's attorney even admitted as much. And the reason why that Binger argued for a $2 million bond was partly based on that.
What specifically triggered it is the return that the court received. When the court mailed notice to the defendant on December 22nd, indicating that there was an arraignment on this case on January 5th, that was sent to the Anita Terrace address in Antioch, which was the address on record for the defendant. It was returned to the court, to Your Honor, on January 28th of this year, indicating that there was no one by that name at that address, and they were unable to forward it to Mr. Rittenhouse. That was confirmation that the defendant no longer received mail at that address, was no longer living there. The court is correct that I made a statement at the initial appearance that I did not believe Mr. Rittenhouse was residing at that address, but that was not, I did not know that he was no longer, that there was no one there anymore. I wondered if it was a situation where the family continued to maintain that residence, but they were spending their nights in a hotel or at someone else's house. That's not unusual, but I didn't know they moved out entirely. And ultimately, whether I know this or not is not the salient factor. The 968 9.10 requires the defendant to notify the court. This is a court order. The court is the one who issues the bond, not me. And even though I had suspicions the defendant might be spending his nights in a safe house or spending time elsewhere, I didn't know where that was. No one notified me of that. I still don't know where that's at. I have no idea where the defendant is spending his time. The court has no idea where he's spending.
Well, it's probably good that Binger doesn't, because if Binger knows where it is, you can bet social media will know pretty soon. This guy has no problem go ahead and disclosing where Kyle is. Take my word for it.
Spending his time. And that's a very unusual and dangerous situation when you have someone facing these types of charges in this case. As I was saying, this is a very unusual situation to have someone facing these charges who's out there free on bond. And what makes this even more unique is that the defendant has no stake whatsoever in that bond. There's no financial incentive for him to comply with bond. He's posted none of the money that's been the $2 million. In fact, there's some sort of dispute going on right now between attorney John Pierce, who posted the bond.
Yeah, the judge isn't going to go for this. And I've seen this before, so I'm not going to try to make it look like I use my fantastic foreshadowing thoughts to be able to figure out what's going on here. But yeah, the judge's not going to go for this. That's a matter of a deal between those two attorneys. The fact is that Kyle has showed up at his court hearings. He's trying to make the claim that this is really dangerous because if he's not putting up his own money, then how do we know he's going to show up for court? Well, then how do you have bail bondsmen? If there was something really wrong with having a defendant scrape up money from other people, they put a law in there about that. The law allows it. It's good.
I don't want to get into that.
Well, I understand, Your Honor, but I think this is salient because
the bond is up. We've got the cash here, so I don't care about a feud between a lawyer and somebody else.
My only point, Your Honor.
Yeah, they've received the money. So what difference does it make how the money was gathered up? Good point.
Is that from the defendant's perspective, what incentive does he have to comply with the bond? What incentive does he have to ensure that the non-monetary conditions are met here? And there's a very
Well, he's showing up at his proceedings, so therefore there must have been some incentive. Probably not wanting to go to jail. That's probably a pretty good incentive. So this is a ridiculous argument here that somehow we need that extra $200,000 to ensure that Kyle shows up at the future court proceedings. But he's showing up at the court proceedings now. And what would an extra $200,000 do? Really what he's trying to say is he wants the bail raised up to the point where Kyle can't afford it so he can throw Kyle back in jail. And I think the judge kind of senses that.
Very small incentive here for him to do that. When facing charges like this, there's a very large incentive for him not to comply, not to come back to court, because there's a great risk here. He could be spending the rest of his life in prison. So when we look at that context, there's very little wiggle room here. The defendant, I think, needs to be kept on a very short leash. We need to make sure that he's compliant with every single part of that bond, which is why I find
this short leash argument. No, I'm sorry, but Kyle was released on $2 million bond. He has right to the same freedoms as anybody else that's been released on bond. This idea that we have to make the restrictions much tighter because he was able to find other people to pay for it. Show me the statutes where it says that you can do that. Bail is a constitutional right. And therefore, to say that, well, because he was able to raise the money from other people and have to pay for it himself, that means we can be stricter on his requirements. I'd like to see support for that.
Filed this motion. And the defense has admitted it. There is no dispute from the defense that they have not complied with 969.10. There is no dispute. They've acknowledged he hasn't resided at that address. And I want to
wait. Well, is that what the statute says? Because when I looked at the statute, which I do periodically, but this one certainly brought it back to my attention again. And actually, what it says, it's 969.03 subsection 1, which pertaining to people charged with felonies. And it says the judge may, in addition to requiring a cash deposit, impose conditions which will secure appearance for trial. And under subsection B, the statute says place restrictions on the travel, associations, or place of abode. Now, I do that with some degree of frequency with people, and not. The percentage would be very low, would be in the low single digits. But if I get somebody who's already out on bond, for example, on a fourth DWI, which I'm really quite uncomfortable with, I will put them on a house arrest, and we require their address. They have to be there. They're allowed often to go to work, but otherwise they have to be in their house. That's a restriction.
Okay, so the judge is saying if you want to restrict a defendant to their home with some minor modifications like being able to go into their job or something like that, you could put that in there. However, he mentioned like the fourth DUI. A person who's had 4 DUIs is a threat when he leaves the home because he might be out drinking and driving, could pose a danger to the public. The judge in the original bail hearing did not impose that. And so Thomas Binger simply misspoke. He mischaracterized what was going on, and you never want to do that with a judge. When you hear a judge say, wait, is that really what it says? And then you make the judge go and read it, and you find out that that's not quite what it says, that's not good. It just looks like you're unprepared. Thomas Binger can't be surprised by any of this stuff. This is a bail hearing. Those statutes that are related to bail are going to be important. He has to be read up on this.
On the place of abode, and it's authorized by statute. You didn't ask for that at the first appearance, and Judge Keating didn't order it. So I don't think it's correct to say that the defendant is required to live at the Antioch address, actually, or any other address.
Well, according to Wisconsin statutes 969.10, Your Honor, a person who's been released on bail or other conditions shall, this is mandatory, shall give written notice to the clerk of court of any change in his address within 48 hours after the change. This shall be printed on all bonds, which it was done here. That was not complied with.
Yeah, that's right. I'm
not complied with that.
I agree with you there. But your statement was he wasn't living there and he was required to, and I don't think that's an accurate statement.
And I think
having an address for the receipt of court notices, which may come in for a variety of reasons, change of date or whatever, having an address, and in fact, when we tell these people, when they give us an address, we say, and some people, for example, are homeless, or they're staying with aunts, 2 nights here and 3 nights there, and rather than locking them up, we say, here's the address, you have to give us an address, and you're responsible for any mail that's sent there. And that's what I interpret the necessity to give an address to mean. It does not equate with placing a restriction on the place of abode, which is specifically a feature in the statute that the court can order, but I couldn't find any record that that was ordered by Judge Keating or that you requested it.
I agree with what you're saying, Your Honor, and I think the distinction you're making between an address and a place of residence is an important distinction in the statutes, and I do understand that there may be a difference between those two things. Ultimately, Your Honor, I think this is a...
No, it's not that there may be a difference between those two things. There is a difference between those two things. The judge made a good point. So best thing to do is probably just admit it. But, you know, the idea of somehow saying, well, you're kind of right. No, the judge isn't kind of right. He's right.
The case where it would be important for the court to know exactly where the defendant is living. As I said, this is an extremely serious case. And I think that it's important that we don't know a P.O. box. We know exactly where the defendant is because of the risk of intimidation to witnesses, the risk to the community. And ultimately, Your Honor, I want to make it clear to anyone who's watching this that the Anita Terrace address, which was on record for the defendant, is no longer his address. It is not associated with him. There is someone new and innocent who's residing there and should be free from any contact, mail, people bothering them, anything like that. You know, the defense is going to argue and has argued in their written submissions that they need to keep the defendant's whereabouts confidential because of fear for his safety. Now, someone new has moved into the defendant's former apartment, and that person is in jeopardy. That person is at risk from the things that the defendant is fearful of. And as recently as 20 days ago, on January 22nd, the defendant misrepresented. He lied about his address to this court by signing a bond with the Anita Terrace address on it, knowing full well that was no longer an address that he lived at, no longer an address he gets mail at, no longer an address that he's associated with in any way. And in fact, someone new is there. And if there's anyone out there that wants to try and find Kyle Rittenhouse, that might be the first place they look, and that person is potentially in jeopardy. So that was a very dangerous and irresponsible thing, a callous thing to do. And that's one of the things I wanted to bring to the court's attention so we can fix that and make sure that whoever's in that apartment is safe and isn't going to be bothered to the extent anybody's out there trying to bother Mr. Rittenhouse. But more importantly, we've got a bond violation here. 969.10 has not been complied with, and there's no dispute about that. The defense is...
He's trying to have it both ways. On one point, he mentioned in the original bail hearing that he doesn't see any real credible threats. There can't be a threat unless it's credible, unless we can verify it. It has to be imminent threat. But now he's making the claim that, well, the people that moved into Kyle's address are at risk here. They could get killed by people that think Kyle's living there. So which one is it? Is publicly disclosing Kyle's address problematic or not? In a sense, he's basically admitting that if the public gets a hold of Kyle's address, bad things can happen to him.
Acknowledge that. They've acknowledged that they failed to update the court with his address within 48 hours. He moved a couple of months ago, and they never bothered to update the court. Now, back in November, I had an email correspondence with Attorney Chirafisi, who was representing the defendant, about this very issue and whether or not they could keep his address confidential. And I advised Attorney Chirafisi to file a motion with the court. That is the proper procedure, Your Honor. If they confidential, they should have filed a motion. They should have filed that motion the moment Mr. Rittenhouse left the Anita Terrace residence. They should have filed it with this court and asked the court's permission But instead, what they've done is gone ahead and done it unilaterally without any court authorization, without any notice to anyone here. They've acted independently. And frankly, this is the latest in a long line of incidents where I think the defendant is essentially thumbing his nose at the court's requirements here. And it's very alarming.
Well, see here, a long list of incidences where the defendant is thumbing his nose at the requirements. Like what? Okay, let's suppose that he's in violation of this statute. And it looks like he is. Okay, fine. But I don't know of anything else. What else has he done that comprises a long list of violations of court procedures and such? Okay.
Someone is facing these serious charges to go to a bar and drink, to wear a t-shirt with a profane message on it, to flash white supremacist signs.
That's it? I don't recall the bond agreement ever being anything about that. He went to a bar and he drank. Looked it up. Wasn't in his bond agreement. He flashed symbols of white power, which, by the way, I think is ridiculous, but wasn't in his bond agreement either. In fact, nothing he did that night violated his bond. But he's making it sound as if this is a long string of incidences where he has violated his bond agreement.
To move away from this address, put someone else at risk, and then refuse to disclose your whereabouts on a case like this, these are very troubling things. Now,
Right, so the threat that these new people are going to experience moving in, why didn't Kyle let the world know where he's going so that he could face those same threats?
aware of the fact that under 969.035, the state could ask the court to revoke the defendant's bond. In fact, there was a protest last weekend. People in the community asking us to do that.
No, I don't want, no.
Well, judge shut that down really fast. Hey, Binger, don't be doing that. I mean, the judge not going to go for this crap. There's a lot of people out there protesting. Who cares? The judge is going to shut that down, and he should. In fact, I think that the judge probably got a little mad about this.
No, I don't want to hear about protests. I don't want to deal with what media reports that are inaccurate. There were some very careless reports in the paper the other day after I issued the restriction on associations.
Wait a minute. Careless by our media? Oh, I can't believe that.
The media nationwide, I guess, portrayed.
Oh, by the way, who's feeding some of that? Thomas Binger. He has no problem whatsoever feeding these things to the media. He knows what he's doing. Well, sort of.
That I had prohibited the defendant from associating with white supremacist groups. There's nothing in the order about that. It would certainly be encompassed within what I ordered, but it was not limited. There was a report the other day locally that said that I think you had issued a warrant for the defendant's arrest. And, I think that's what it said or something. The DA's office issued a warrant for his arrest. And this kid, look, I want to have a fair trial in this case.
Yeah, well, you might want to get a couple of different prosecutors there. And by the way, by saying, I want to have a fair trial here, you're destroying Thomas Binger's strategy. He's like, no. That's Binger's only shot, is to find some way to subvert justice here. So, yeah, this is kind of crazy. But the other thing about the media is that Binger started laughing about the whole warrant thing. If you go onto social media, how many people have been bandying around that there is a warrant out Rittenhouse's arrest?
And I want everybody, I mentioned this in my earlier order, I want everybody to act in a way that maximizes the possibility of fairness in this case. Fairness to everybody who's involved. And I don't want to, this case is not going to be decided by demonstrators of one type or another. And frankly, it's not going to affect anything I do, and I don't think it's going to. I don't want to whip stuff up, so it affects a fair trial in this case to decide it strictly on the evidence. So
they're not going to try to persuade the judge. They're going after the jury. they're going to try to put in the minds of the jury that there's going to be protests, there's going to be burnings and stuff like that if Kyle is set free. And that's coming. You watch. You wait until you see some of the news items that are going to be coming out. And guess who's going to be feeding that? It's going to be the prosecutor's office.
So I don't want to hear about a demonstration last weekend, okay? Because if we do that, then tomorrow we'll have a demonstration by people who view things differently, okay?
And that's why I had filed a motion for a gag order in this case, which is still pending on all the parties, because this should not be something that's tried in the media.
Demonstration? How do you gag a street demonstration?
The gag order was filed when Attorney John Pierce interviewed on national news about the case, Your Honor. That's but
my point is the less anything other than just strictly discussing what the facts and the evidence are occurs, the more likely we are to have a trial that's fair to the defendant, which is his constitutional guarantee, and to the public, which is my responsibility.
So I think the judge is getting a little bit annoyed with Binger's continual bringing up of the other attorneys involved. The judge doesn't care about that stuff. He doesn't care about John Pierce and all that. He basically said, look, show me the facts, show me the statutes, I'll make a decision off of that. But unfortunately, that takes out half of Thomas Binger's playbook.
So,
understood.
I interrupted you. Go ahead.
I was just making the point, Your Honor, that under 969.035, the court does have the ability to revoke bond in a case like this. However, there is a burden on the state proved by clear and convincing evidence that it's necessary to protect the public or prevent the intimidation of witnesses. And at this point, I don't believe that I could meet that burden, which is why I didn't ask the court to revoke the bond here. However, I do think that there is a basis with the course of conduct that we've seen here for the court to impose a consequence for the defendant's violation of the bond, which has been admitted by the defense, to increase his bond by $200,000. And until he does so, I think a warrant should be issued for his arrest. Now, I don't know how long it's going to take him to post that money, but I think that that's something that needs to happen here, because otherwise there's no consequence on it.
Actually, there's a statute about warrants. There's a statute about warrants in these cases also. 969.08 subsection 5A. A court may issue a warrant for the defendant who has already been admitted to bond only if the district attorney complies with 969.08 subsection 5A, and that requires, number one, that the defendant was released on conditions, which is the case here. Number two, alleges the defendant violated a condition of release by committing a serious crime, which I haven't seen any allegation of that. And number three, that the district attorney provides a copy of the complaint charging the commission of the crime. So
basically the judge is saying, this wasn't a play by you because of your sensibility or reasonableness. It's what the law says. By the way, Binger, you really don't need to be heading over there and trying to read this stuff. This is a bail hearing about warrants. You shouldn't have to look this stuff up. When he's reading it to you, you should know this. How long have you had to prepare for this?
You're short on two conditions in terms of my issuing a warrant. Now, tell me if I'm reading that statute wrong.
No, you're not, Your Honor. I'm not alleging the defendant has committed a serious crime. I'm simply alleging he's violated the conditions of his bond by failing to update his address with the court.
But it says, let's get the exact wording.
I'm not a lawyer, so I can only guess here, but I think if you're making the judge head to the statutes all the time, that's probably not a good thing. If I'm a judge, and not, so I can only guess at this, but I don't think I should have to head to that all the time. I think you should present to me what the statutes say, and you should be prepared. The fact that the judge knew about this particular law and you have to look it up is not good. By the way, if you want to see our money going down the drain, look at 88 Zap. What has he done? Well, he's been standing there taking notes. This is all being recorded. So we're paying this dude, I don't know how much. Well, Wisconsin's paying this dude how much? So many dollars an hour, and he's sitting in his hearing doing nothing.
Yeah, it says, if the court, this is subsection B, subsection 1, 969.08, subsection B, subsection 1, if the court determines that the state has complied with paragraph A, the court may issue a warrant. That's the limitation on the court's authority to issue a warrant, is if the district attorney has complied with paragraph A. And paragraph A is what I just read, and you're missing two of the three ingredients that would be required to empower me to issue a warrant. Unless I'm reading that wrong, and I don't think I am.
I understand, Your Honor. I am asking the court to increase the bond, however.
Go ahead.
So everybody on social media, oh, they're going to be going after issuing a warrant for his arrest. He can't. So all this time, the prosecution has been feeding the news media that they're seeking a warrant for the arrest of Kyle Rittenhouse. They can't. And if they knew the statutes, they would have known that. The judge read it out. He says, you're missing two of the three elements. And this is not a matter of interpretation. This is not a matter of, well, we're kind of close. If you read the statutes, it simply does not allow you to issue a warrant for his arrest at this time. You, under no circumstances, should have been telling the public that you were seeking a warrant for Kyle Rittenhouse's arrest. You saw what it did. Everybody out there thought then, oh my gosh, they're going to be shackling him in and probably surrounding his house with SWAT team members because, you know, he's going to open up with this AR-15 rifle. They're not going to take him alive. So you get to see how this stuff is being fed. This is how the prosecution has been operating.
Thank you, Your Honor.
Is that it?
Oh,
Mr.
That's
Richards?
all I have, Your Honor. I believe Ms. Motley and maybe Attorney Art, also on behalf of the victims, would like to give a brief statement as well. And I would ask the court.
You know that I don't permit the use of the term victim before adjudication in this or any other case, and I haven't for years. So please don't use that term. And I know this is an awkward situation, but I do not permit the terms victim or alleged victim unless and until there's been an adjudication. So,
thank you, Judge Schroeder, because I have been saying this for a while now. I dislike use of the term victims in these things. Kyle has not been convicted yet. Therefore, it has not been established that the people he shot are victims. And I certainly don't think that Huber is a victim. He wasn't shot. Yes, he has an emotional attachment to the case, but he himself wasn't directly harmed. So to call him a victim is a bit much.
So these are folks who are speaking on behalf of the families of the deceased?
Your Honor,
yes.
John Huber is the father of Anthony Huber, who was killed by Mr. Rittenhouse, and he's here in yellow, and he would like to address the court if Your Honor will hear from him.
He's dressed in a t-shirt. A t-shirt? To a court? All right, maybe times have changed, but man, I would not be happy to see that. You're dressing a judge, dressed like a gentleman.
Go ahead. Would you identify yourself again, sir?
hello, my name is John Huber, and I am Anthony Huber's father.
Okay, and would you do me the favor if it's okay if there's nobody else there? It's going to be a lot easier for the court reporter if you remove the mask.
I
don't want to jeopardize anybody.
If he removes his.
Yeah, I'm not going to, sir. Sir, I'm talking about the reporter. If I ask Mr.
All right, here I am.
I vote that we have him put his mask back on.
To speak, yeah, go ahead.
Can you hear me better now?
Yes, sir. Thank you. This is Mr. Huber. Go ahead, sir.
Okay. Well, from the beginning, from the moment he became a killer, he thought he was above the law. And he has no remorse for what he's done. And he is.
Well, Kyle thinks that he's innocent, so why should he have remorse? I mean, this argument has gone too far. Kyle is claiming self-defense. He's claiming that your son tried to kill him. Why should he feel remorse for it? Your son hit him with a skateboard and then tried to grab his gun. And therefore, in his mind, your son tried to take his gun and shoot him with it. Therefore, he's not going to show remorse because he doesn't think he's done anything wrong. And as an accused, You can't assume that he has done something wrong. The fact that he has shown no remorse would be something to play up maybe in a sentencing hearing or in a probationary hearing, but not in a bail hearing. If he shows remorse now, you would show that as evidence he's guilty, and therefore we should raise his bond because now he's even admitted that he's done something wrong. Look how sorry he is about what he did. You can't win with these guys.
Is enjoying this media circus and the support from these hate groups and militia members that have posted his bond. Okay? It's not like his...
The judge at this point has tuned him out. This is called a rant. And while the judge will go ahead and let him say his piece, this is one of the most unpersuasive arguments you're ever going to hear. The judge is not going to be swayed by this. He seems like he's a kind of an old hand at this. And he understands that, yes, John Huber is going to be very emotional here, and because his son was killed, he gets that, but he's not going to be persuaded by this.
His mom and dad put up the family house to get him out. He has nothing to lose if he runs.
Well, why hasn't he run? Why is he here today? If you're claiming that he has nothing to lose by running, then why hasn't he run? What kind of fugitive shows up at his bail hearing?
Nothing to lose. Matter of fact, he's probably going to spend the rest of his life in prison if there's justice in that town of Kenosha. He should be remanded to custody. I don't know about what the DA was supposed to file, but this kid, we don't know where he is. You don't know where he lives.
To be honest with you, I'm kind of glad that you don't know where Kyle lives. And in fact, I think the judge is thinking, like, you're the kind of person who might go out and do something to him, which is understandable. I mean, if somebody killed my son, yeah, I mean, they might want to hide that person's address from me, but the court can't look at it that way. The court is going to try to keep Kyle's address such that people like John Huber can't get to him.
Nobody in that court knows where he lives. And if it's supposed to be a secret, if he's got all this back in, what is he afraid of? Got all
people like you.
All these people supporting him. You know, why does he need...
What a terrible argument. He's got all these supporters, so what does he have to be afraid of? The very fact that for every supporter he has, there's another person out there that would probably like to see him dead.
He need to be in a safe house. His bond should be $4 million, like I said in the beginning. It should have been something that he can't just raise on his own.
Oh, wait a minute. How does that work? It should be so high that he can't raise it on its own. Therefore, he would need help from others, which he did, which you're criticizing. I can't sort this dude's argument out. I think what he meant to say was that he should have a bail so high that Kyle can't raise the money even if he had help from outside. But in that case, that denies Kyle bail, and he has a constitutional right to bail. Now, keep in mind, I understand that you can deny bail to people, but to raise an amount up so high that such that the person can't make it is probably unconstitutional. We assign a bail amount so that the person could raise the money. And if they could raise the money, the fact that they did means that they're more likely to participate in future proceedings, which he has.
You know, and the people that did raise his money, I guess they're not around anymore. But
wait, what? I guess the people who did raise the money are not around anymore. What the hell where did that come from? I get it, he's upset and he's sort of winging it here, but oh man, that's a terrible argument.
We lost a son. His mom and I lost our son. And how would you feel if the killer of your son is just able to walk free and make videos in bars and live it up?
Well, that argument would deny bail to everybody, no matter what they did. I'm telling you, man, if somebody scratches my truck's paint, he's not getting bail if I'm the judge. He can rot in jail. Hell, I might not even give him a jury trial. Might have him executed. Somebody scratching my truck. See the problem with that argument? The reason why we have a judge is that he is not a person who has had his son killed, and that allows him to be objective. And what he is saying here is you should put away that objectivity and be subjective about it. Pretend like this was your son. You can't have judges like that. It's a terrible argument.
Whatever the statutes are, they must be wrong, because this guy can just go and do whatever he wants after he killed our son.
Whatever the statutes are, they must be wrong. Well, guess what? The statutes are what the judge is going to go by, not your arguments.
Our son didn't get to spend Thanksgiving with us, but Rittenhouse did. He got to spend all kinds of time at the bar, live it up, making videos with his white supremacist friends, singing videos with a shirt that says free as F. You're not going to be free as F. Justice is going to be served to you.
Getting in close to where the judge is going to stop him, but the judge is going to go ahead and allow him to say it. Judge isn't swayed by this. This is a terrible argument, and he's just going to go ahead and let him say his piece. He is the father of the deceased. He gets it. You can't be too strict about this kind of thing, but he came close to having the judge step in.
That's all I have.
Thanks, Mr. Huber. Who wants to talk next?
Your Honor,
yes, Ms. Motley?
Thank you. Your Honor, if my client, yes, Your Honor, if my client, Mr. Grosskreutz, would like to say a few words, and then I would like to speak after him, if it's okay with the court.
Yes, ma'am.
Thank you.
Good afternoon, Your Honor. My name is Gage Grosskreutz. Can you hear me all right?
Yes, sir. I think the reporter's having a little bit of difficulty, but just hold on 1 second. We're just having a technical issue here. Okay, now go ahead, sir. Thanks.
Thank you, Your Honor. Again, my name is Gage Grosskreutz. I'd like to keep this brief. First off, I'd like to
So would we.
Echo the concerns and grievances that the DA has provided, as well as the clearly emotional issues that Mr. Huber has just stated. Again, I would like to restate that it is, in my opinion, that Mr. Rittenhouse has shown a pattern of lack of remorse during this bond time before trial, and I would also recommend that the bail be raised to $4 million. Thank you.
Thank you, sir.
That's it? That's your argument? You had, what, 3 or 4 days to present your argument, and that's what you came up with?
Ms. Motley?
Your Honor, thank you. And I would like
here it comes.
to have my remarks on behalf of all the victims that are present. I have been given permission of that.
I'm sorry,
survivors. I'm sorry. You're
this
right.
is a long-standing rule.
I appreciate
it doesn't apply just to this case. I never permit this, and it's been for years. Usually we talk about the complaining witness. I understand this is a little difficult, but the decedent or whatever, but I can't permit the use of the word victim or alleged victim because they're so loaded with things that can't be assumed prior to trial. So go ahead.
Thank you, Your Honor.
Wait, is she representing Huber as well? So I thought that the other guy, I can't read it. This dude here on the bottom left, I thought that he was representing John Huber. Maybe I missed it.
My apologies for that. So I am speaking on behalf of the survivors, if that's a more acceptable term. Mr. Huber has also given me permission to speak on his behalf, as well as obviously my clients, Mr. Gage Grosskreutz and the estate of Joseph Rosenbaum. We want to support the state's motion, and we strongly believe that Mr. Rittenhouse's bail should also be substantially increased. We believe collectively as survivors that that increase should be at a minimum $4 million. We are very disturbed by his behavior in terms of what we believe is violations of his bail conditions. He should be giving his address.
It's not about what you believe. If you think that he violated bail conditions, state the evidence, state what the bail conditions were, show us how he violated it. But we believe that he violated his bail conditions. It holds no sway in front of a judge. Judge doesn't care what you believe.
That is a basic requirement that I have seen as a criminal defense attorney and as an attorney for over 17 years of criminal defendants all around the world. And so why he feels that he doesn't have...
What, is he applying for a job?
...to give that address is beyond me when he signed his bail conditions on November 20th when that was set. We'd also ask the court to add additional conditions to his bail, to his bond, his bail requirements. We believe that electronic monitoring is appropriate. We believe that, I don't know if Mr. Rittenhouse has a passport, but if he does, that should be surrendered, or he should not have the ability to get a passport. We believe that his movement should be confined from home to his attorney's office, or court. We're extremely disturbed, like everyone else, with the fact that Mr. Rittenhouse, as Mr. Huber has said, appears to be, living it up. I believe what he said, going to bars.
I'm sorry, but he's out on bail. He's allowed to live it up as much as he wants.
Throwing up white domestic terrorist, white supremacist signs while wearing inappropriate attire, in my opinion. Chugging down 3 beers within a 90-minute time period is not something.
3 beers in 90 minutes. Kid's a lightweight. I can put down 3 in 9 minutes. Oh, hell, I could put down 3 in a hell of a lot less than that.
That we believe that he should be doing as a person that's facing over 200 years in prison. So we'd ask.
Okay, so these are the things that we don't think he should be doing. It's not about your opinion. What did the bond agreement say? Did he violate it? No. Your sensitivities aren't important here.
Court to take everything that we're all collectively saying in consideration, that being out on bail essentially is a privilege, and Mr. Rittenhouse has shown time and time again that he does not care about his bail conditions. Thank you.
Time and time again about his bail conditions, even though he didn't violate any of them. So they set new bail conditions. Has he violated them? No.
Thank you, Mr. Richards.
Thank you, Your Honor. When one looks at the bail, first off, the exchange between the court and Mr. Binger, if this court today were to say to my client, I want you to post an additional $200, he would voluntarily return himself to jail. He is not running. He is not hid. Mr. Binger knew from the beginning he was not living at the address in Antioch. Mr. Sharafazi contacted him after to try to make arrangements to provide an address under seal. I find it ironic that Ms. Motley finds that so upsetting when her client, Mr. Groskowitz, has a sealed address in his Milwaukee County Circuit Court case.
Your Honor, my client.
Yeah, the judge's not going to go for this. We're dragging Gage's stuff into the proceedings. They're not relevant here. However, the fact that Crystal Kaiser has been given a bail of $400,000 for murder, somewhat interesting. I don't think the judge would allow that any more than bringing up Gage's situation.
Is not on trial.
Look, I don't want to get into a Milwaukee case involving anybody.
Thank you. Thank you.
Move on to something else, Mr. Richards.
My client, when Mr. Binger talks about the Antioch address, Mr. Binger has said he wants proof of threats, clear, present, and tangible. Yet he's talking about this person in Antioch being somehow at risk. That makes no sense. It's intellectually dishonest. The notice went out to the Antioch address. It was returned. I note to the court most important, that on January 5th for the arraignment, which was the notice, my client was in court through Zoom. He was in my office in a timely manner. He's made all of his court appearances. He knows the government is seeking to up his bond today. He's here. He's appearing via Zoom. That's how the court has required it. The fact that
My video last night, I said one of the arguments that Mark Richards could offer is, guess what? He has shown up at all his court proceedings, and he's making that claim right here. Whatever the case about getting hold of Kyle Rittenhouse, either through forwarding a mail, whatever, he is making his appearances. And I think he's making a fairly good case here that even though Kyle Rittenhouse may have broken the letter of the law, the spirit of the law is still intact. Kyle has shown up for his court proceedings. The purpose of bail is to ensure that he does show up.
That Mr. Binger uses the word unusual 15 to 20 times does not go into the bond statute. My client has filed under seal, and I'll fall on the sword. I should have been more diligent about getting that taken care of, but I didn't. Mr. Sharafazi reached out. It was unsuccessful. There were other attorneys involved. I should have made sure it was done. But as soon as I was served with these documents, we did provide a P.O. box, which is very close to his residence. He looks in that P.O. box, or his family does, daily. To believe that my client isn't at risk, we've provided the threats. All it takes is one crackpot, and there's a problem. My client.
Another argument I offered last night was that you don't have to have credible threats to be in danger. And in fact, the very people who want to kill you are not going to threaten you first. They're just going to do it. And so to wait for a credible threat to manifest first is problematic. I mean, by then it's too late. He's not making quite the same argument, but along the same lines. It only takes one person. And is there one person out there that wants to see him dead? Oh, yeah.
Has appeared for every court appearance. He has done what he's supposed to do. The bond has been updated, and if he moves again involved, I should have made sure it was done. But as soon as I was served with these documents, we did provide a P.O. box, which is very close to his residence. He looks in that P.O. box, or his family does, daily. To believe that my client isn't at risk, we've provided the threats. All it takes is one crackpot, and there's a problem. My client has appeared for every court appearance. He has done what he's supposed to do. The bond has been updated, and if he moves again, we would update that. There's no notice to me under the statute regarding EML, ELM, or a passport. My client does not possess a passport. There's a substantial bond posted by people who support Kyle Rittenhouse. That is true. It's going on in another Kenosha County court case also. My client will appear. He looks forward to...
He was, I think, alluding to Crystal Kaiser. She was a young black female who has been on murder charge for a while now, and she was bailed out for $400,000 by a Illinois-based organization that collected the money and was able to spring her. I'm glad they were able to. Now she's free to go out and prepare her defense. She is not guilty until convicted by a jury. So she is innocent until proven guilty, and the very fact that she's out on bail is great. And as long as she shows up for her court appearances and doesn't hurt anybody, I have no problem with it.
Litigating these offenses in Your Honor's courtroom, we have nothing to fear. The truth will set my client free. Thank you.
If I could respond very briefly, Your Honor.
Go ahead.
First of all,
This is Mr. Binger.
counsel wants to put me at the center of this as if my knowledge is what matters, but I don't run the court. I'm not the judge. And the statute doesn't require him to notify me. It requires him to notify the court. This is a court order. This is a statute that isn't complied with. And what I just heard from Attorney Richards is no defense, no argument, that they've complied with it. It's an acknowledgement that they didn't. They've just completely blown off this requirement. I had my suspicions he wasn't actually living there anymore, but as I explained earlier, I didn't know that that meant they'd completely flown the coop, and I certainly didn't know someone new had moved in there until I sent detectives.
Did you see the look by Judge Schrader? He was not happy about that. Like, what are you talking about? And I think he was referring to the flown the coop deal. Kyle is there. I mean, he's right next to his attorney. The statement "flown the coop" makes it sound like he's a fugitive from justice, and that's ridiculous. He's right there. And I think the judge didn't just thought that was just really inappropriate.
Down there to double check it after the court got its notice on January 28th. So that's the biggest point here, Your Honor. What the defense has filed is a address under seal, which is a P.O. box. It's not in Wisconsin or Illinois. So now we're even.
I did look at that, and it actually looked like an address to me. You're saying that's just a P.O. box?
On Google Maps, Your Honor, it's a P.O. box. Counsel's just acknowledged it's a P.O. box. I had my suspicions when I saw the format of the address. It didn't look like it would be a normal address. It's a P.O. box, Your Honor. So again, we don't know where an accused murderer's at. That's the bottom line here, Your Honor. The court doesn't know, and the defense is refusing to tell us where someone is accused of murder is located. And I think that's a problem. I'm not okay with that. The statutes don't contemplate that. And there's no dispute here. The defendant hasn't complied with the
Wait a minute. Where are you?
Go ahead, I'm sorry.
Okay, I wasn't understanding what you were saying. Go ahead, I got it now.
I'm simply asking that this defendant be treated the same as everyone else, whether it's an OAR or a disorderly conduct or a drunk driving or a sex assault or a murder. Every defendant is required to provide this information. The defense is acknowledged.
Binger blew it there. He basically said, I want him to be treated just like everybody else. Now the judge is going to think, well, how have I treated everybody else? We'll see.
They didn't do so. So now it's up to the court. What consequence is there going to be for this? Are we just going to turn a blind eye at this and let this go by? Or in this very, very serious case, are we going to hold the defendant to the same rules as everybody else and impose a consequence for us? And I believe that it's appropriate that the court impose the consequence that I've asked for, which is to increase the bond by $200,000. Now, I note, as the court mentioned in 969.08, I think what the court was talking about there is the ability to arrest and hold the defendant without bond pending trial. And that's not what I'm asking for here. I'm simply asking that he be required to post the $200,000. And I think the court has to issue a warrant for his arrest to make him do that, because otherwise there's nothing compelling him to post that money. Oftentimes.
That's kind of odd. Normally, I would think you would increase the bail amount, and if the person does not provide the money, then you go arrest him. I don't know if you arrest the person first, but then again, I'm not a lawyer. I don't know. Maybe that is the case.
Sometimes the courts will say you need to post it by a certain period of time, whether it's 5 o'clock next Tuesday or something along those lines. But if he doesn't, then obviously there'd be a violation of the bond. There'd be an arrest warrant. There could be new charges on that. And I acknowledge we do have the ability to file bail jumping charges on the defendant for violating this bond. But in the big scheme of things, that goes back to the same point I was making earlier, which is there's not much of an incentive here. A Class H felony for felony bail jumping pales in comparison to first-degree intentional homicide charges, which is what the defendant's.
Well, then why did he show up? Why is he here? If there's no repercussions for him to leave, and you're making that claim because the prospect of having to go to court is much greater, then why is Kyle showing up at his bail hearings? And by the way, I think the judge kind of knows that the reason why Thomas Binger wants Kyle arrested, he wants the public relations part of it. He wants to have Kyle taken in chains, and therefore he could take photo ops. This is all about a play to the public. They don't need to arrest Kyle Rittenhouse to levy an extra $200,000 bail on him. All they have to do is just levy the extra $200,000 on him with a threat of jail if he doesn't pay it. So this is about publicity. This is how the prosecution is working this into the public deal. They want a public arrest of Kyle for the optics.
Facing right now. So it's a very little incentive for him to continue to comply. without the monetary incentive, without any legal recourse, the defendant can continue to flaunt these bond conditions and continue to.
Well, flaunt these bond conditions. The only one that he's flaunted is this disclosure of his address, but you're making it sound like he has just done nothing since he's been bonded but break his bond agreements. This is the only one.
To act like none of this matters and he doesn't have to comply like everybody else. The behavior is disturbing here, Your Honor. This is a very serious case, and I'm not sure the defendant is taking it nearly as seriously as he should. He should be held to the same rules, same standards as everybody else. And when he violates a court order like he's done here, and he admits he's done, there should be a consequence.
Okay, so the question now becomes, why didn't you allow his address to be sealed? As Mark Richards says, Kyle would have offered his address if you had agreed to it. They want his address in the public eye. This is all about playing to the public.
Thank you.
Your Honor, may I add something to that?
I'll go ahead.
Okay. Thanks, Your Honor. And joining in what the state said, 30 days ago, the court, not this court, but there's another Kenosha County case involving also a double homicide where a male of color.
Okay, so she's going to bring up yet another case. And I think she should have gauged that Judge Schrader doesn't seem to be interested in this stuff. Every time that somebody has tried to argue on behalf of something else that has happened to some other defendant or to some other accused, he shut it down. And here she goes.
Given a $2.5 million bond, $2.5 million. And we ask that the court also take that in consideration, since Mr. Richards found it necessary to bring up something that was not relevant to this proceeding. We think that this is relevant for the court to consider when setting the bond conditions and increasing the bail if the court so orders. Thank you.
Well, I will tell you that I am not going to decide anything in this case or any other on the basis of the color of anybody's skin.
That was her mistake. She played the race card, slipped it in there. Another person, a person of color, the judge is thinking, yeah, the race card, here she goes. He's going to shut this down completely. To bring up another case as evidence was not going to sit with him to begin with. And to bring up the fact that the other person is black is really not going to sit well with this judge. She should have read him better than this. He's not going to go for this.
Period. There was a decision made, in, I think it was 1896, Plessy versus Ferguson, where a decision was made on the basis of the color of someone's skin. A man who is, by the way, is 1/8 African-American descent. And it was a test case. And the Supreme Court of the United States, which has a spotted history on these issues, I'll digress enough to talk about Roger Brooke Tawney saying that a black man could never be a citizen of the United States in 1854, which brought on the Civil War, and Plessy versus Ferguson, where Justice John Marshall Harlan issued a stirring dissent critical of the 8-1 vote of the court to permit segregation in by state law in transportation, and said what an outrage it was and what harm it would cause to the country. And we suffered for a long time because of that, because decisions were permitted to be made on the basis of that. I don't know anything about that other case. I don't know who the judge was. I didn't set this bond, and I didn't set that bond. And so I'm not going to comment at all about that, other than to say this case came to me. It had an initial bond of $2 million set by Judge Wagner, who may be the same judge who set the bond you're talking about. I don't know. It was reset by Judge Keating at first appearance, and what's been reported now He was not put under condition of living at a specific address. That could have been done. The district attorney apparently was aware of what he now refers to as flying the coop, was aware of that situation back then, and he didn't ask for a conditions on place of abode, and Judge Keating didn't order it. So there's no change in circumstance there. I do not believe it's proper to issue a warrant. I don't think that would be lawful. No matter what feelings anybody has, I took an oath to uphold the Constitution.
Oh, ouch. Boy, he nails them there. Well, first of all, he goes into a lot of background on Plessy versus Ferguson. I think he's showing off a little, but the thing that he basically said was, I don't care what the emotions are. He recognizes that what he has heard here are pure emotional arguments. For example, the increase in $200,000. Thomas Binger has yet to make a comment or make a claim that increasing that $200,000 bond would somehow protect the community or ensure that Kyle Rittenhouse shows up in future bail proceedings. And all that Thomas Binger has done is said that, well, he violated his conditions and we want to raise it up $200,000. He broke the rules, so we want to levy a fine on him. That's not going to sway this judge. The judge is going to say, look, I want logical arguments. If you want to increase his bail by $200,000, tell me what that's going to do in the mechanism for it. And her claim here about people of color and all that, he wasn't swayed by that a bit. You'll notice that they are all trying to try this case according to what has happened elsewhere. Now, if she had come in with an argument where it said, look, here is what the research shows that the average person gets for this type of murder, that would at least have been a logical argument. But instead, she's basically saying, well, this person over here got $2.5 million. Why can't we make him $2.2 million? That's not an argument. That's terrible. And she's not exactly the brightest bulb in the drawer.
And follow the laws, and that's what I'm going to do. And it's sad that this is getting at the level it is, but apparently was aware of what he now refers to as flying the coop.
See what I mean? I knew that phrase bugged him when Binger said he's flown the coop, and the judge went, oh, what? And now he's bringing it up again. That was not a very strategic choice of words.
Was aware of that situation back then, and he didn't ask for a conditions on place of abode, and Judge Keating didn't order it. So there's no change in circumstance there. I do not believe it's proper to issue a warrant. I don't think that would be lawful. No matter what feelings anybody has, I took an oath to uphold the Constitution and follow the laws, and that's what I'm going to do.
So he's saying, I'm going to follow the law no matter what the emotions are. See, he's recognized it. What he's hearing are a bunch of emotional arguments. And he's not particularly swayed by them. Nor should he be. Forget the emotion. Think about this from a legal, logical standpoint. The attorney wants Kyle's bail raised by $200,000. Show us how raising the bail by $200,000 A, ensures that Kyle is going to participate in future court proceedings, or B, protect the community. That's what this is about. He doesn't. Instead, he talks about Kyle broke his conditions, so we should levy a $200,000 response, as if the $200,000 is a punishment. And I don't think the judge likes that argument at all.
And it's sad that this is getting at the level it is, but I can't help that. I will tell.
It's sad that it's getting to the level that it is. I think he's recognizing that the arguments these people are putting together are really just an emotional hodgepodge. And he's kind of wincing at it. He's saying, like, I really would like it if everybody in front of me put forth statutes, case law, and good arguments. But instead it's, well, there's another guy over there in Minnesota, and he he doesn't have to pay the $200 million or whatever. That's not the way it goes.
Tell you that the violation of not, well, most of the people who are out on bond, we don't know where they are. There are people who are out on bond who are they're business people. I've had cases where people they do international business and they fly all over the world while they're out on bond, and there's nothing prohibiting them in that bond. This is a border county. A significant portion of the people we have out on bond are living in Chicago or one of the other collar counties, and are in and out of Illinois every day. So we don't have these restrictions on travel except when the judge, following the statute, puts an abode condition on. That was not done in this case. So he didn't violate anything like that. I don't have the authority to issue the warrant the district attorney is talking about, and I don't agree with his analysis of what the circumstances, or I should say the procedure for getting the bond changed. I get people in here and I do change their bonds, and then I tell them to post it by a certain time, or they have to report to the jail. If they don't report, that's when the warrant gets issued. But to issue a warrant now for a defendant who's appeared at every hearing, that would be I'd be breaking the law.
And Binger should have known that. Binger didn't do his homework. If he had read the statutes carefully, he would have known the judge would have been all over this, but he didn't. He wasn't prepared. And to cite statutes and get it mixed up, the judge didn't fall for it. He heard what Binger was saying. He said, wait a minute. That's not what it says. And I thought, oh no, you'd never want to do that. And so Binger has not been impressive at all.
And I'm not going to do it. I disagree with your statement that bail is a privilege. Bail is a right in the Constitution. And posted the bail that was set. Now, he's in violation of a condition about updating his address.
I'm sorry,
And
actually, is this all to me?
I'm talking just generally.
Okay, got it.
I'm talking to everybody. Actually, if he'd have left a forwarding address, that probably would have been full compliance with the bond order, because we're interested in an address where we can send notices to the defendant to appear for a hearing or whatever the case may be.
Okay, so this is what a seasoned judge can do. He basically took this complex gruel of all these arguments that have been bandied around on the internet, and he has drilled down to the main deal. And he said, look, if Kyle had left a forwarding address, then none of this would have happened. So really the only thing this is about is the fact that Kyle did not leave a forwarding address. And therefore, all of these high emotional comments that he is showing no remorse, he's showing no respect for the court. Basically, he said, look, it's just going to be a simple matter here. Kyle should have left a forwarding address, and he didn't.
He apparently didn't leave a forwarding address. At least that's the evidence that was returned to the clerk. So he's in violation. I can tell you, and I talked to the clerk about this yesterday to confirm what I thought. There are a very, very, very high percentage of people who are out on bond who, she routinely asks after a hearing is done, are you still living at the same address? And I would estimate the number of cases where the person says yes is over 10%, maybe significantly more than that, where the people say, yes, I've got a new address, and they haven't notified the clerk. They're in violation. I've never jailed one of those people. I've never heard of any other judge jailing those people. I have never seen a bail jumping violation based on one of those things. I've never seen the district attorney bring anything like that into the court. We amend their their address on our records, and they might get barked at a little bit about violating the court's order. But that's the extent of what happens, and they don't get a raise in their bond of a 10% raise in their bonds. That's
So Binger said earlier, remember, we just want Kyle treated just like everybody else is treated. Well, the judge is saying, okay, well, how have we treated everybody else? Let's see here. Old Joe Schmo, I remember him, and he didn't leave his forwarding address. And when he came in, it turns out that he had moved and he didn't notify us. And what did I do to him? Nothing. What about old Nancy? I remember Nancy. She came in and she had not notified of us or her new address. And what did we do to her? Nothing. And so now he's looking at Kyle saying, wait a minute, we didn't do anything to those people. Why should we do anything to him?
I can't recall that ever happening. I'm sure it hasn't. He didn't. So he is in violation for not updating his address, and that has to be addressed going forward. But he also, as Mr. Richards has pointed out, he appeared on the last hearing, which was the one, which was the return notice. He was there at Mr. Richards' office. So I'm assuming he came from wherever he was to Racine to attend that meeting, and he's here today. So I'm going to deny the motions.
Wait, what did John Huber just do? Let's go back. Did he just flip off the judge? Dude, you just flipped the judge off. Okay. The judge didn't see it, but he's going to see it later. Dude, you might be getting a pretty hefty fine here. That was dumb. Show up in a t-shirt, flip off the judge. Yeah, that's not going to look too good. You might be wanting to hide your address from the judge here going forward. But yeah, flipping off the judge. In Florida, saw a case on YouTube. Girl did that. She got in some serious trouble. I think, didn't she get like almost a year? Or something like that. Or, no, I think it was like 3 months jail. So, John Huber, that was really, really dumb.
I do think that I understand the concern, and my heart goes out to everybody who's involved. This is a terrible thing, and that
except John Huber, who just flipped me off.
It's one of the reasons I feel so strongly. I want it to be handled peacefully and fairly and impartially, and part of that, just a small part of it, is the risk that there would be the kind of concern that the defense has talked about in terms of the safety of the defendant. And quite apart from the interests of the defendant, after what this town has been through in the last 6 months, I don't want any more problems. The police don't need any more problems. We don't need to have people's safety in jeopardy in any way. So I think that the desire that the bond or that the defendant's address be kept from public scrutiny is a legitimate one.
Keep in mind, Thomas Binger said, no, we should have it disclosed to the public because we have a long-standing tradition of open records here in Wisconsin. Judge is saying, no. We've had enough heartbreak. Enough people have been hurt. We don't need more people hurt. And therefore, keeping Kyle's address secret is probably a good idea.
And what I'm going to order is that the actual physical location of the defendant, and it will be his place of abode. If he's going to remove from there, he'll have to follow the bond condition and give us the exact physical location of his place of abode. And that is to be given to the deputy clerk working in this court, who will keep it privately. It will not be part of the public record. It's to be given to me. It'll be held the same way. And it's to be given to whomever the sheriff designates as the person who would be responsible for full knowledge of the whereabouts of the defendant. And that is to be kept secret by the sheriff's office. So is that clear, Mr. Richards, what's required?
It is, Your Honor, and you and your clerk will have that by 5 o'clock today, and I will have it to the Sheriff's Department as soon as I'm told who to designate it.
For full knowledge of the whereabouts of the defendant. And that is to be kept secret by the Sheriff's office. So is that clear, Mr. Richards, what's required?
It is, Your Honor, and you and your clerk will have that by 5 o'clock today, and I will have it to the Sheriff's Department as soon as I'm told who to designate it to.
Okay.
Your Honor, I would also
any
information be shared with our office too, please.
No.
Binger says, I want that address so I can get there on social media and leak that out somehow. The judge says, no, we're not going to let you have it. Now listen to the arguments that Binger is going to offer.
District Attorney's Office, and the answer is no. That has nothing to do with you or your office. I think the sheriff would be your right arm, left arm, whichever is preferred, in discharging anything that would need to be done. And they're not to share it with you unless you offer good reason. And it's not that I don't trust you. I think that the less of this, the safer everybody is. As I said, you remember what went on 6 months ago here? I've got 2 broken windows here, right here in this courtroom. The doors are all still covered with plywood. A good share of the community is still boarded up after millions of dollars of damage.
Hey, the prosecutor better hope that this guy is not the judge for the upcoming trial, because he does not look to be happy about what happened to his courthouse. And Binger is going to come in and say, well, we need to keep tabs on Kyle and stuff. We'll see how the judge handles that.
Property damage and this ghastly event occurred. So no, I don't want anything that might kindle further violence. And so, no, it's not a reflection in any way on you or your office.
Your Honor.
Which the judge says, it's a reflection on you and your office, because if you guys get a hold of the address, it will be on social media within a week.
I hope you're not suggesting that sharing this information with our office is somehow going to lead to further violence, because we would not be in any way contributing to that, but our obligation is to help monitor the defendant's bond conditions, and without knowing where he's at, that becomes very difficult. If I'm to file
Yeah, the sheriff's going to monitor that. That's not your job. The other thing I should mention is that District Attorney Michael Gravely, his buddy is Billy Violent. Billy Violent is a BLM agitator. She's pro-violence, and he texts her all the time. They go out to breakfast. And would you want that person knowing Kyle's address? Oh, hell no. Hell no. I'm glad the judge snipped this one out.
A charge of felony bail jumping, for example, for the defendant violating his bond, and I don't know where he's at. That makes it pretty difficult. And if the court has placed the
you call the court?
And
call the court?
Criticize me for not doing so in the past, then I feel like I need to have this information. And certainly no one on this Zoom call needs to be reminded of the events of 6 months ago. We have the loved ones of 2 deceased and a victim who was shot in the arm by the defendant that night. So
here we go with the victim thing. Oh man, Binger, quit doing that. Stop it.
Please don't use the term victim.
The Mr. Grosskreutz was shot in the arm.
Witness.
Your Honor, if Mr. Binger wants my client,
what's that?
If Mr. Binger wants my client to appear on what he's going to do next, which is issue a felony bail jumping, send it to my office. He'll be in court the next day. This posturing is not serving any purpose at this point. The court has ruled.
Your Honor, it's not posturing. This is standard procedure in all criminal cases that everybody knows where the defendant is. This is highly unusual for this to be withheld under seal. The court has ruled that it can be sealed from the public, but we are not the public. We are the prosecuting agency. We are the prosecutors on this case, and we have a very important right to know this information as the prosecuting agency in Kenosha County. And I have never heard of a situation where this information has been withheld from our office. The Sheriff's Department.
I'll be stepping in here. You're right. This is very unusual, but it's also not very usual to have a district attorney who is buddies with one of the BLM agitators who is pro-violence. And so the judge, I don't know if he knows anything about that, but if I was in the judge's seat and I knew about that, there's no way in hell I would give him Kyle's address. No way in hell.
You're right, is a law enforcement agency, but we work with them, and to withhold them from giving to us, the court not giving it from us, to cut us out of that information is not appropriate here. Our office is headed up by the elected DA, the chief law enforcement officer in this community. This is a murder case.
Who has breakfast with BLM agitator Billy Violent.
And we are entitled to this information, Your Honor. We have never been denied this information in any case that I've ever heard of. And if the court is aware of a case in its history where you've not shared this information with us, I would appreciate you sharing that with us, letting me know what case that was, because this is highly irregular. We have a right to know this. I would argue the public has a right to know it as well. I understand the court's ruling from sealing it from the public.
That was a mistake. To say that the public has the right to know it, but we understand why they're not getting it. That was a mistake. He should never have gone there, but it wasn't going to matter. The judge isn't going to give his office Kyle's address, because I don't know, I get the feeling that the judge kind of knows that if Binger gets a hold of Kyle's address, Billy Violent is going to get a hold of Kyle's address.
But our office has a responsibility to enforce the laws, enforce the bond here, to file bail jumping charges if there's a violation of that, and we cannot do our job without this information.
Sure you can. It's called call the sheriff. If you really think that Kyle has jumped bail, if you really think that he has given you a fake address, you call the sheriff and you tell the sheriff, I need you to go investigate this. And then the sheriff will investigate and then come back and say, no, he is at the address that is stated by the court. That's all you need to know. This idea somehow that you're going to be out there sleuthing around, monitoring Kyle, it's ridiculous. And the judge is going to tell you that in just a moment.
If the sheriff can keep on top of this as to whether there's a violation, that's where most of your information, when I was district attorney, and I know it's been a long time, but I didn't have any investigative staff except one investigator, which I won't go into, but the sheriff's department was in charge of reporting bond violations and the like to us, and I think the same situation is true now. Hearing's over. Thank you.
The defendant doesn't reside in Kenosha County, Your Honor. The sheriff can't help me because he doesn't reside.
Thank you. Thank you.
Good afternoon.
Okay. Good afternoon.
Well, a few more points here. Let's give a big hand to ADA. Is it Jason Zapp? Doing a fantastic impersonation of a bump on a log, chewing up Wisconsin's tax money by just sitting there. There's nothing that went on here that he couldn't just watch later. And by the way, the real performer, Gage Grosskreutz, he didn't fall out of his chair. Excellent job there, Gage. You're really doing a lot better. Kim Motley was a waste. I knew that when she showed up, I was like, oh no. She is one of the worst of the race card players. That's really her only strategy. She tried it. He basically knocked that thing away. And Thomas Binger, he's in over his head. Kyle had violated a bond statute, and Binger got nothing. He misplayed the judge at every turn. He really had very poor arguments. If he had come in and said, look, we need another $200,000, here's why. Another $200,000 would secure the participation of this kid at future proceedings, and given a reason, the judge might have went for it. He didn't. Instead, he came in saying that, well, Kyle, he has violated this bond agreement. We should punish him. by making him pay another $200,000. And the judge was like, look, I don't know how that fits in with the whole purpose of bail in the first place. So yeah, this is just really bad. And I think that this is giving everybody a little taste of what's coming in the upcoming trial. A lot of these little tactics that the prosecution has been playing in the public, you see how well that works against a real judge. Judge ain't gonna go for this stuff. And while the public will fall for it every time, and we saw how they fell for it, right? Kyle is being arrested. Kyle, they're looking for him. He's a fugitive. All that stuff that they fed to the media, the actual public went for it. They fell for it. Judge is not falling for it. And I don't think that the judge who's going to be actually doing the trial, I don't know if it's going to be Schrader or not. I don't know what the laws are in Wisconsin about that. But whatever judge they get is probably not going to go for it either. All these little tricks, all these little emotional arguments about him drinking at Pudgy's, and he was flashing white supremacist signs. It's not going to play in front of a real judge. They're going to throw that stuff out. They don't care. As far as John Huber goes, dude, that was really not good. You are probably going to be feeling the wrath of the court over this one. The only thing that will save your hide is the fact that you are the father of the deceased. They might cut you some slack on that. The judge might look at that and say, well, he is probably under a lot of emotional strain. It's not worth bringing it up. Maybe not do something, but you might get a good hefty fine out of this, and you might even end up in jail for a couple of days. I've seen worse happen. So I think what the public is now reeling, because you could see it on Twitter, because I'm going to do another one of those Twitter hilarity videos that I did and about this case. And I think that they're starting to see that, oh shoot, this is not a given. They thought that the prosecution was going to come in here and just, slap old Kyle Rittenhouse all over the place. And they're finding out, no, it's not working like that. And it's only going to get worse for them. I have said many times, they have no case here. Their evidence is completely lacking. Their arguments are terrible. They have no chance whatsoever of getting a conviction. Pinger couldn't even convince a single judge to go along with a $200,000 bail increase. What chance does he have of convincing 12 jurors to unanimously send this kid to 60 years in jail? You tell me. And I think the people are starting to see it. Binger, Gravely, got themselves a real loser here. They better devise another strategy. And frankly, I don't think they have one. I think that this deal they are trying here, playing it out in the public, in the court of public opinion, bringing in other cases that they can allude to, I think that is pretty much the only strategy they have. They're trying it. It's not going anywhere. Like my video and subscribe to my channel. And stay tuned for another Twitter hilarity. It's coming.